Welcome to the 2020 Virtual Spring Meeting, brought to you as a special edition of Our Curious Amalgam, the American Bar Association Antitrust Law Section's podcast. Virtual Springs Eternal, Friday, April 17th through Friday, May 1st, as we bring to you some of the top programs from the now canceled in-person spring meeting, as well as new hot off the press programs discussing the most compelling issues of the day. Be well and enjoy the show.
Hello and welcome to the Virtual Spring Meeting. My name is John Roberti. Today, we are delighted to present another great panel, Big Data as an Antitrust Issue. And the panel is presented by the Media and Technology Committee. With me today to provide some context are Sergey Zavlosky and Anna Chitova. Sergey is counsel at O'Melveny & Myers and is one of the co-hosts of Our Curious Amalgam podcast. Hi, Sergey.
Hi, John.
Anna is senior counsel at Dish Network and Sling TV and a vice chair of the Media and Technology Committee. Hi, Anna.
Hello there.
All right, Anna, let's start with you. What is today's program about?
Well, today we're talking about big data and antitrust, and why we all know what antitrust is, and we see the term big data everywhere these days. I thought what would be good to think about what is our common understanding of what is big data. And the way I view it, these are more complex data sets, especially from new data sources. Think about geolocation, think about healthcare information from your Fitbit. And these data sets are typically so voluminous that traditionally we would not be able to process them with software, and we cannot manage them. But because of the advances of computing technology, we can do that, and we can address business problems that we were not able to tackle before. Think about using artificial intelligence to identify certain categories of customers for advertising purposes. So that's what's big data.
Sergey, let's turn to you. Why is this important, what we're doing today?
Well, John, data is becoming an ever more important part of the economy as companies find new ways to monetize data and use it to fund services that consumers rely on. So from a business perspective, big data is a big deal. From a legal perspective, big data raises some novel issues. There's a lot of debate out there about whether traditional tools of antitrust analysis are sufficient, or if new tools, new approaches, and maybe even new laws are required. And if that's not enough, I think data is particularly important in light of the ongoing COVID epidemic, or pandemic rather, as data may play a large role in different countries' efforts to contain the spread of the disease. And these efforts are likely to precipitate a public debate about the trade-offs between the benefits that sharing data may bring and personal privacy. And that debate may end up being very influential on how we think of big data going forward.
Sergey, thanks. Anna, let's back to you. What are you hoping to get out of today's panel?
So as Sergey mentioned, this is a novel and evolving issue, and it will be important to understand what are the interactions between antitrust and other considerations such as privacy and data security. And another thing that I would like to learn more about is how do competition concerns apply to different kinds of data? Is all data created equal, or are there unique sets of data or types of data that warrant different treatment under the antitrust laws? And last but not least, I think it's important for us to understand and see how governments and antitrust agencies around the world are thinking about big data. Are the current antitrust laws and policies sufficient to handle the new challenges that big data presents? And what some of the directions and thinking of those regulators in antitrust agencies and governments? I think that will be something that I would love to learn about.
Okay, Anna and Sergey, will you stick around and let's listen to the panel together and then come back at the end and we can talk about some of the takeaways. Anna, Sergey, is that okay with you?
Sounds great, John.
Great. And we're also going to have our friend Amadou Ribeiro stop by, and he's going to talk to us about a related antitrust law section initiative that he's involved with to report on common issues in the digital economy. Very important, very interesting stuff. So stick around. Now, with that, let's send it over to the moderator of today's panel, Ankur KAPOOR. Ankur, the floor is yours.
Thanks, John. Welcome, everyone, to the American Bar Association Antitrust Law Section's virtual spring meeting session, Big Data as an Antitrust Issue. My name is Ankur KAPOOR, and I am a partner at the currently virtual law firm Constantine, Kenneth. Along with Greg Louis at Deckard, I co-chair the section's Media and Technology Committee, which is sponsoring this program. First and foremost, I want to thank the section staff for converting the 2020 spring meeting from what would have been the section's largest in-person meeting ever to the section's largest virtual meeting ever. They've done it without missing a beat, and it's truly amazing. Some folks may wonder why competition and consumer protection lawyers take the time, especially now, to discuss the issues raised by big data. On Friday, April 10th, Apple and Google announced that they were partnering to develop COVID-19 contact tracing technology, using Bluetooth-enabled mobile phones to determine when individuals had been in contact with someone who had voluntarily informed public health authorities that they had tested positive for COVID-19. The problem of the COVID-19 pandemic is a data problem. The virus has spread like wildfire because it is so often asymptomatic. An article in the New England Journal of Medicine identified 4 critical questions in fighting the pandemic. First, what is the full spectrum of disease severity? Second, how transmissible is the virus? Third, who are the infectors? How do the infected person's age, the severity of illness, and other characteristics of the case affect the risk of transmitting the infection to others? And fourth, what are the risk factors for severe illness or death? How can we identify groups most likely to have poor outcomes so that we can focus prevention and treatment efforts? Those critical questions are all big data questions. The virtual spring meeting brochure's description for this session asks the question, has data become the new oil that drives the global economy? I think the history that we're all living now has posed an additional antecedent question. Has data become the economic resource necessary for getting our global economy back on track? With the increasing number of competition authorities around the world opening investigations or taking enforcement actions involving big data, and now the role of big data in dealing with COVID-19, 2020 is already looking like a big year for big data. To address the antitrust and related issues raised by big data, we've assembled a highly experienced all-star panel. Peter SWIRE is professor of law and ethics at the Georgia Institute of Technology's Scheller College of Business and is associate director for policy at the Georgia Tech Institute for Information Security and Privacy. He's also senior counsel at Alston and Bird in Atlanta, Georgia. Peter is a former White House privacy official and was a member of President Obama's review group on intelligence and communications technology. Vandy HOWELL is an economist with expertise in industrial organization and labor economics, and is senior vice president at Cornerstone Research in San Francisco. She focuses on antitrust, intellectual property, marketing, and class certification matters, including in information technology markets. She is also a vice chair of the Antitrust Law Section's Big Data Task Force, which has published part 1 of its report, Artificial Intelligence and Machine Learning, Emerging Legal and Self-Regulatory Considerations. Andreas MUNDT is president of the Bundeskartellamt, Germany's antitrust enforcement agency, which handles merger control, enforcement against cartels, and abuses of dominance. President MUNDT has also chaired the steering group of the International Competition Network since 2013. It should go without saying that the Bundeskartellamt is one of the most active antitrust enforcement agencies in the world and has recently been prosecuting an action against Facebook concerning Facebook's data collection practices. We are honored to have President MUNDT join us at this time, given all the efforts of the Bundeskartellamt to ensure that coordinated efforts to deal with the pandemic do not sacrifice the benefits of competition and consumer protection. Ken Paxton is the Attorney General of the state of Texas and currently in the middle of his very antitrust-oriented second term of office. General Paxton is the state's top law enforcement officer, leading more than 4,000 employees in 38 divisions and 117 offices around Texas. That includes nearly 750 attorneys who handle more than 30,000 cases annually. We are honored to have General Paxton join us as well. I can't imagine all that he has to deal with, even when there is no global pandemic. His presence today certainly speaks to the importance of the issues that we're addressing. I'd like to start with Peter SWIRE. Peter, would you mind kicking off the discussion? What are some of the important competition, privacy, and security policy concerns and trade-offs when it comes to large data sets and their use?
Thank you, and a pleasure to be on this call, on this podcast. So what I'm going to talk about very briefly is what's often called data portability, or in Europe is sometimes called data sharing. And from an antitrust competition point of view, opening up data is going to allow more competition. So there's one academic paper out recently that's called 50 Facebooks. If you could get the data from one Facebook and have it go into 50 companies, then they could compete in a very robust way. And there's an enthusiasm about the competition gains that come from opening up data. On the other hand, there's privacy issues. So an individual agreed to give his or her data to one company, and then suddenly it's in 49 other companies. That's going to be a trouble under the European General Data Protection Regulation. It's going to be a privacy issue. And even for the individual who says, yes, I'm in favor of it, then they're transferring data of other people, like the other person in the photo. There's also security issues. Data portability can be a wonderful thing to open up competition and get data to new places. But it could be that a hacker or a bad person pretends to be the person with the right to data, and then the portability technique opens up the data to exfiltration of a lot of data, a big security breach. So having taught competition and privacy and security, I'm now working on a portability impact assessment. How can we have a set of structured questions that would work through competition and privacy and security and intellectual property and other issues, and in order to have some reasoned view about when to open up data from portability or not? I think the different regulators will benefit from really speaking to each other. So I'll stop there, I think.
Thank you, Peter. That's a great way to set the table, and it's certainly intuitive and makes sense that when you open up, as you said, 50 companies having the same data as Facebook, that certainly raises privacy concerns, but it also does, in fact, enable those 50 competitors perhaps to compete better. But at some point, there's enough competition. So I'd like to turn to Vandy. Vandy, how do you identify, for example, market power in data markets, and how do you identify any competitive effects? How do you assess competition from an economic standpoint?
Thanks, Ankur. So I think you have to be very precise with your question. So, first, it's the threshold question, which is, is data the product that the company is selling, or is it instead a byproduct of or an input into the company's business processes? And these are different situations, and you would frame them differently. If the company sells data into a marketplace, then we can consider what the scope of the market for selling that data would be, and whether a given firm has market power in that market in a traditional way. So you can imagine a company that sells data on financial transactions to a broader market, and you could look and say, well, what are the customers of these data products view as substitute data products? And who else is selling these data? And are there any limits on how much more they could sell? And how difficult would it be for a new competitor to enter and provide these substitute products? But if the data at issue isn't something a company is selling, but is instead a byproduct of or an input into the company's business process, you need to look at it differently. And this has been the focus in a lot of new discussion over the past number of years. It's just how and when does this lead to market power? And in this situation, the issue isn't, do I have market power over the data I sell? The question is more, how does the data I'm collecting during my normal course of business impact my ability to compete in my business relative to others? So this has been raised in discussions about large tech firms that transact their business electronically, so search engines and large online retailers, social networks, and electronic device makers. But they're not the only firms that are moving into the digital economy this way. It's also true for brick and mortar firms. So McDonald's bought multiple AI startups last year, and Walmart spent decades building up immense amounts of data from its stores, but also its inventory management practice. And medical device firms have large amounts of data testing their devices, and firms that have trained AI processes to read mammograms have both used and created large amounts of valuable data, right? So I think it's like we can be safe in assuming that one strategy that successful firms will use in the digital age is going to be to collect data, to create data, and to analyze data in order to compete. And they might do this by offering free services to consumers in exchange for data and advertising, or they might do it by selling products and collecting the data through that process. And the better firms are going to distinguish themselves from their competitors and attract more customers. So it follows that a company could be faster, stronger, and better than its rivals, in part due to the data it's collected. And this would both be a result of the firm's strength as well as cause. And, to Peter's point, it might be that 50 additional competitors having that data might make those competitors really happy and might lead to a form of competition on the margin. But the question is the holding of this data by the successful firm in and of itself market power of antitrust concern? And I think, economists would typically say no, right? And in fact, to force the sharing of that data might be viewed as harmful to competition because of the reduction in incentives to innovate and create it in the first place. So there's been recent discussion of how owning better data in combination with other behavior might lead to or be implicated in anti-competitive effects. And I know my co-panelists are going to be discussing those in more detail, but I'll just list them off, which is, in markets for two-sided platforms in which having many participants on one side is valuable to the other side and vice versa. Sometimes it's more difficult for small competitors to compete, and what role does data have in that? Or self-preferencing. A competitor that offers some aspect of search may also compete upstream to that search, so a search engine that provides content, or an online retailer that provides products. Could it self-preference using its data in search, its own products, and then advantage itself? Or collusion. If firms own better data and they can more easily see each other's data digitally, does it make it easier to collude, and how do algorithms fit into that? And then there's also issues around acquisitions and incumbent firms potentially acquiring other firms in order to get their data. And, is that something that leads to efficiencies and good things, or does that lead to reduced competition in the future? So I just want to stress, though, that these are all things that are a plus, an addition to holding the data itself.
Thank you, Vandy. President MUNDT, thinking about how Vandy just described two different ways to look at big data. One as a product that a firm might sell, and second as an input that a firm may collect. How did the Bundeskartellamt approach the problem in its assessment of Facebook?
Well, I think we have to be aware that if we look at at least some of the tech giants, we are confronted with the fact that it is up to data and network effects that these companies have got this kind of dominance that we have. And if we look at it this way, we have to wonder ourselves as competition agencies, how do we combine privacy issues on the one side with competition issues on the other side? In other words, can privacy play a role in the assessment of the competitiveness of the market or in the assessment of the dominance of a company? We have an explicit provision in our law in Germany which says that access to personal data is one key parameter for assessing dominance, market dominance. So we have to find a way how to include that into our assessment. The way we did it in Facebook was a little bit with respect to the question, what do we do if a super dominant company systematically violates privacy principles as a part of the business model, and thus gathers data, which is a fundament of the dominance in a way that we find is not legal as far as the gathering and the processing of the data is concerned. So I firmly believe if we want to assess correctly dominance based on the gathering and processing of data, we have to take a look at the proceedings, how these companies gather data and how they process data. So if we need an assessment of these data-related issues, as competition agencies, we have to make a choice. Either we develop our own parameters in assessing this data collection and data assessment, or we rely on parameters that are already there, that are already in the world. And here, at least from a European perspective or as a German perspective, GDPR comes in, because with GDPR we have a very good parameter to assess how a company gathers data, how a company processes data. Of course, we could develop our own parameters, but that would be complex, that would be very complicated, and of course we would create a huge amount of legal uncertainty for a long time, because we would need an assessment by the higher courts if we did it the right way. But going back to GDPR, we have parameters that we can apply, which are already in the world and which are reliable. So this is the way we did it in the Facebook case. We did not look so much at the fact what Facebook does when you are on the Facebook website, because I think every user is aware that his data collected is collected there. So we looked what is happening off Facebook, which means what is happening to your data as user when you are on company-related websites like Instagram or WhatsApp. What happens if you're on third-party platforms where you see the like button, the share button, and what happens if you are on websites where Facebook analytics comes in. And here we thought we found an infringement of GDPR. We came to the result that the data, which is the basis for the dominance in this case, is not collected in a legal way, and that thus Facebook is abusing its dominant power in the market. We imposed far-reaching restrictions on Facebook's processing of the user data. A key point of these restrictions is that Facebook has to keep data collected from various sources separate, and is not allowed to combine it if the user contradicts this combination. And still, the user should be allowed to use Facebook or other services in the future. You might know that our decision is under appeal. The higher regional court in Düsseldorf has suspended our decision in the proceedings for interim relief. We have appealed on points of law to the Federal Court of Justice to clarify this issue. And the hearing is scheduled for June this month, whatever a hearing in these times might mean with regard to COVID-19. So to make a long story short, I think data matters for the assessment of dominance. Data matters a lot for competition. And we need to find parameters in order to assess the way this data is gathered and processed. There are numerous ways by dealing with data as a competition agency. We try to restrict the collection of data. that is the second solution. We might also find ways to grant access to certain data. We might come to this later on. And data portability might be another issue, but portability includes that there must be other competitors you can turn to with your data. Otherwise, data portability will not get you very far when it comes to competition. So in a nutshell, that was our approach.
Thank you, President MUNDT. General Paxton, unlike Europe with its general data protection regulation, the United States has to date largely left privacy concerns to the individual states. So we don't have a single regime that governs the norms of what data collection practices are, for lack of a better word, legitimate or lawful versus unlawful. How is Texas, and you certainly work with your counterparts in other states, how have the states approached the lack of consensus in the United States as to how data should be collected?
Well, hey, first of all, thanks for having me on your discussion today. I'll address this sort of from our state's perspective. As you may or may not know, on September 9th, 2019, just under a year ago, state AGs from 48 states joined together to announce the launch of an investigation of potential anti-competitive monopolistic practices on the part of Google. Investigation is ongoing, so I can't really speak to the details of our concerns, but suffice it to say that we believe there are reasons to be concerned that Google, in particular, is a monopoly in ad tech marketplaces and is using its monopoly power to harm competition. The use, or rather misuse, of data is one type of conduct that raises the potential for harm to competition. And as I will discuss hopefully later, one of our concerns relates to the use of data in the online advertising market. And of course, it's not the only concerns that the state AGs have about Google, but it is a central focus, especially in my office. Thus far, the state AGs have been working diligently to investigate Google's anti-competitive practices. At this stage, we are in the throes of discovery, issuing subpoenas to Google and third parties, gathering information, and developing the evidence. It is a huge undertaking, but fortunately, we are well armed for the fight. We have a strong relationship among the state AGs. We have hammered out agreements among the states on staffing, cost sharing, and leadership of different aspects of the investigation. We communicate with each other at the staff and AG level on a regular basis. We also have worked extraordinarily close with the DOJ on this investigation, so we're pleased with the current progress that we're making. And of course, the coronavirus has raised questions about our ability to move forward with the investigation. I would echo what Attorney General William Barr said last month. While taking appropriate health precautions, we are continuing to investigate uninterrupted. The staff in our office and other state agencies are working incredibly hard to gather information and to continue our investigation despite the pandemic.
Thank you, General Paxton. Vandy, generally, although not always, data is considered, I think, what the economists call a non-rivalrous and non-excludable good. And to my understanding, or at least to what Google tells me, there are often many alternative sources of data such that it's costly or it's impossible to keep others from obtaining substitute data. And I think that's what the economists mean by non-excludable. And also, one firm's use of the data doesn't prevent the other firms using, say, a copy of that data. So it's called non-rivalrous. How does that impact the competitive analysis, particularly as it pertains to economies of scale or network effects that may contribute to market power?
Thanks. It's an important question. And I think you're right in the context of consumer data that the way people typically talk about it is that it is non-rivalrous and non-excludable generally. I think it's not disputed that many different entities are gathering identical or similar consumer data at the same time. And so the implication for competition is that if the data can be gathered by many and used by many, that this points to lower barriers to entry. it also means that there's a large marketplace in which consumer data is aggregated and sold. And to pick up on something Peter said earlier, and I think it is running through President Moon's comments as well, the sale of data is great for competition, but there are privacy considerations around that, and those are trade-offs. But in general, there's lower barriers to entry for data when there's many collectors of the same data. And if you think about location data, as an example, your phone and multiple apps are collecting it, and not just map apps, but others, your car, your smartwatch, they're all collecting the same data at the same time. Or your purchase data, many different entities are collecting these data, including your credit card company and other payment services, as well as the brick and mortar or online retailers you're using. So you've got many collectors. And then also, consumers can multi-home and easily switch, typically, which can lead data to be unlikely to be excludable. So consumers can switch between providers of products and services, like if you think about Uber and Lyft, consumers can have both apps on their phone, and drivers can use both apps, so it's multi-homing. And consumers can move across search engines or retail stores. So when these features are present, it just points to low barriers to entry. And so what does that imply for network effects and economies of scale? A feature of many platforms is that they provide economies of scale. And so the economic question of great interest is, does that mean that more data is always more valuable and that competitors can never catch up around, and this is around, the data. So do competitors need all the data that an incumbent has on its servers? Is it a nice to have or is it a must have in regard to competition? And I think there are some other features of data that make it undermine in some ways the idea of economies of scale. So one is decreasing returns to scale. So imagine you have a data set with 100 million observations and 10,000 variables. How much value is derived by adding the next 100 million observations or the next 1,000 variables? And could a firm effectively compete with some scale but not all the scale? And that's an issue around economies of scale. It's also that data is not free. So it's expensive. It's cheaper than it's ever been, but it's still not free to collect. And so is the marginal data of the same value? If the marginal data is not the same as the first 100 million, how does it compare to the cost? Older data also gets stale. And data may be useful, but not the necessary ingredient for providing, competitive innovation, even in the platform context. So data doesn't provide the value on its own. You need engineering talent and quality service, and you have to figure out what customers want. And so it follows the competitor may not need data of the size of the incumbent. Rather, they just need to have access either to purchase or some strategy to accumulate the relevant and timely data. And they may not need data at all. And, Tinder's, I think, a fun example because, it's pretty clear that an online dating platform has network effects. More people and more data are better. And Tinder launched into a market that had many existing firms with lots of types of data. So they had their networks and they had their data. But Tinder became a market leader in a year, and it didn't have those data or those networks. And how did it do it? It came up with an interesting user interface, and it gave customers what they wanted. So Tinder may be using the data it has now to evolve and develop its service, and that could benefit users, and that may frustrate its competitors. But that doesn't imply that its data are now a barrier to entry or a means to exclude competition.
So something similar to what perhaps happened with Instagram and Facebook once upon a time before Facebook bought Instagram. President Moon, how has the Bundeskartellamt and its European counterparts looked at issues of entry by startups, upstart firms, innovators into markets characterized by big data?
Yeah, that is a difficult question. I think Vandy has laid out the fundament very well. Data has always to be assessed on a very differentiated basis. We have done a joint study with the French Autorité de la Concurrence, our sister authority in Paris some years ago. And we have looked at the question of big data and competition. We have seen in that study, and we have laid out in this study, that data is not the same as data. You have to assess it on a very careful basis. And of course, there is data that can be bought on markets, huge amounts of data, by the way. There is data that can be reproduced. So data is not necessarily the barrier to entry, but data can be the barrier to entry. It's a case-by-case analysis that you have to do and by which you have to look at it. And if you look at the huge tech giants, I assume that the data that they have is very special. To me, this always seems to be like a trove of data they're sitting on. If you look at the 3V, velocity, variety, and volume that these companies have, this is very special. And I doubt very much that any company can reproduce, replicate, or buy this kind of data that is gathered and processed by some of the companies, not by all of them. You always have to be very careful with data because you always have to see that data is, it takes a lot of investment to gather all this data. So as a competition agency, you should be careful not to go into cases where you might destroy the business model of a company, although this data that is in place is maybe not such a barrier to entry and doesn't play such a role with regard to dominance, whereas there are other companies where it is pretty clear that the fact that they own all this data makes it extremely difficult for other companies to enter the market. And this is why we think about changing the law in Germany with regard to these data trolls, and look especially at constellations that I have just pointed out, where data might play an eminent role in order to enter a market and in order to do any business. For example, we think of cases where a company might be involved in the creation of data, but the data is with another company, and the one who has contributed to the data doesn't have access to all that data, although they have been involved in the creation. And this is the case where you might want to open the data trove for another company. So, as I said, it's a very differentiated assessment that you have to take here. You have to assess the role of data in the specific case. You have to assess the specific quality of the data. You have to assess which role data plays in a certain business case. And only if it all comes together, then you might have a case. So it's a very nuanced assessment I would like to take here.
Andreas, in cases where a data set or a certain kind of data are truly a barrier to entry to competition, does European Union or any national law on, for example, refusals to deal or essential facilities provide European competition authorities with a legal basis to compel competitors to have access to those data? And should it?
I'm afraid there's no easy answer to this. We haven't had these cases yet. As a competition agency, as a national competition agency, we haven't granted access to data yet. Others in Europe have. As I said, we are about to amend our competition law, and we are about to amend the essential facilities doctrine here in Germany, because so far we believe that the essential facilities doctrine, as we have formulated it in our law, provides mostly, let's put it this way, doesn't provide for the access to data so far. We try to apply it in the offline world. There's the famous Scandline case where we try to provide access to a harbor for a second ferry service, but we failed before court. So you see that already in the offline world, it is difficult to apply at least the German essential facilities doctrine. So we can imagine how difficult it might be in the online world with regard to data. So in principle, it should work. And I have the impression that the European essential facilities doctrine is a bit broader than the one in Germany, and that could allow for access to data already. But in Germany, we prefer now to make it a bit more safe and to include it in the law that the essential facilities doctrine can also be applied to cases where the access to data might play a role. So I can only give you quite a differentiated question here. I think in principle it should work already, but as the head of a competition agency, before I move towards such a case, I would be very, very happy if we would do that more on the grounds of legal certainty in a certain way.
General Paxton, in the United States, while the law certainly exists to compel an owner of certain property rights to grant access to its rivals, to its competitors, to others who wish to use that property, we have such a strong notion of property rights in the United States that it is a rare occurrence. How have you and the other state AGs resolved that tension with the idea that there may be companies whose data should be shared with other parties, including their competitors?
Yeah, I'll give you the same answer that Andreas gave you, which is there's no easy answer. But federal law and monopoly practice are nuanced and flexible, and courts have found ways to reach anti-competitive conduct in emerging technology industries. In particular, in the United States, courts have wrestled with the question of whether monopolies may refuse to deal with their competitors. Given the ongoing Google investigation that we're a part of, let me just offer a few general thoughts on the topic. Serious questions arise when a monopoly controls a market and denies a competitor reasonable access to a product or service that is necessary in order to compete. Examples would include some you're familiar with, Microsoft and its control of its operating systems to deprive rivals from access to necessary inputs and distribution channels. Another is a recent Seventh Circuit decision denying a motion for summary judgment regarding Comcast's monopoly power over one segment of the cable advertising market to allegedly gain a monopoly in a related advertising market so as to control its smaller cable competitors. One can think of the control of data as a strategic bottleneck that may violate antitrust laws if a monopolistic controls the data and fails to make it available to its competitors. Competition concerns arise when dominant platforms can leverage their unique access to data to identify and then exclude actual or potential competitors from the market. In the digital advertising context, targeted advertising by definition requires access to user data. Competitors that hope to compete with Google in the digital online marketplace may not be able to do so if Google maintains a strategic bottleneck on access to critical user data.
Thank you, General. You've clearly learned quite a bit of antitrust in your second term as AG. Couldn't have said it better myself. Peter, often, particularly when it comes to social media platforms, data portability is often discussed as a potential solution to competitive concerns. Is it a cure-all, or is it just a placebo?
Well, it's a trend, I can say that. So when GDPR went into effect a couple of years ago, Article 20 has a right to data portability across Europe. An individual can get his or her data out. The California Consumer Privacy Act has basically instituted the same regime for California, which means for many companies across the country. All the major federal privacy legislation that's being proposed contains a right to data portability, so if something moves in Congress, we'd have a national law there. But beyond that, beyond the individual portability, there's also been a trend to have what the Europeans call data sharing, which is what you might think of as wholesale portability, when databases get moved all at once. And in the United States, Health and Human Services issued its interoperability rule just last month in March. And in that rule, it mandates for health IT companies, health software companies, that they have to let, for instance, a hospital move its data, all of its customer data, to a different software system. They can't lock in the hospital or the other health actor. And so we're seeing regulation about mandated portability so that people are not locked into software. That exists in Europe under what's called the FFD directive. It exists in Arizona in some laws around automobile dealers. And so my research is finding a wave of these portability laws that haven't really been put together. And I think when you look at them together, you see a much bigger push for portability. But then the question after that becomes, when does it make sense or not make sense? It makes sense for our phone number portability so that we can move from one phone carrier to another. That's a simple one. It's secure and private usually. But the security and privacy and intellectual property issues become much more intense when you get into some of these other areas. So it's a trend. Whether it's going to solve every problem, I think probably not, because we can't open up all the data when there's reasons to be careful about data as well.
I would like to underscore a difference, too, that Peter just brought up that seems important, which is the individual portability of data versus the need for an organization that is also collecting that data and using it to offer an aggregated, tied up with a bow package to its competitors. Right, so I think, what's been great about a lot of this privacy regulatory changes is that increasing portability of individuals essentially makes the data non-excludable, because individuals can move if there's a better product and they can take their data with them. And that's a different approach than to view the data that has been collected by an organization as an essential facility and have to turn it over in a package. So I just think it's an interesting difference.
And that package, and I'll see President MUNDT, that package exists in this HHS regulation where the intent of the rule in part is to allow people to take their data out of existing healthcare and put it on apps and have a lot of people move their data out of the traditional systems. And so we really are seeing some innovation in the law here.
As I said, I see three different approaches to deal with data as a competition agency. One is the restriction of data, one is to grant access to data, and one clearly is the portability of data, and it's right that is included in the European GDPR. The problem I always see is do not forget about network effects. That is the second factor, one of the key factors that gives this kind of dominance to companies and which make them so big, so huge by itself. Which means you might have the possibility of portability, but where to turn to? Where are the competitors? They are in some cases hard to find. Imagine you want to switch from one platform to the other, but there are no competitors you can turn to. So I think if we achieve a world where we have more competition among platforms, among networks, I think that is an aspect that might work very well, but for the time being, where we see highly concentrated markets in some areas of platforms and networks, I think that doesn't have the full impact it could have if we were in a more competitive way. By the way, portability does not guarantee interoperability. That's another aspect that you might want to include. So it is a means, but for the time being, I'm skeptical if it can have the impact already that we thought it might have when we were introducing GDPR.
So this is Ken. I just wanted to comment on the portability issue. From my standpoint, my job is to protect consumers. And so while this may not be a panacea to some of the other issues we deal with as it relates to privacy concerns and consumers potentially profiting off their own data and these companies not profiting so much off of their data, it does offer consumers some control over their lives and their data. So I think it is, while not a cure-all, it certainly is something that I think would be very helpful to consumers, giving them more control over the massive amount of data these companies are collecting on them.
That's an excellent point, General. I think given the big data that reside in the minds of our esteemed panelists and the non-artificial intelligence represented on this panel, I'd like to pose the final question. Using your predictive analytics, what's next in big data? General Paxton, would you lead us off?
That's such a great question. I don't know if any of us really know. Maybe I'll be proven wrong today by the panel, but I do think that there needs to be more regulation, whether it gives consumers control through portability or control through just protecting their privacy and their data being used. So I do think technology obviously moves faster than government, but I do think both state and federal government are becoming really aware of some of the issues that relate to some of these big tech companies having so much information and so much control over people's lives through this information. And I think you're going to see both at the state, federal, and local level more regulation designed to protect consumers in the future.
Andreas.
I agree. I believe that we will see more regulation around the world, probably not only in Europe, but maybe also in the United States. We are working here on an amendment of the competition law where access to data plays a certain role with regard to the essential facilities doctrine, but there are other provisions in there that some might say have some regulatory impact. I say this is not regulation in a sense that we have seen it in the past, like a sector-specific regulation. I call that competition law plus, which means that we try to go to the root of the market power of these companies, and that we try to find out why they are really so dominant and how we can deal with this. So we will see more precise provisions in competition law, which go a little bit in a regulatory perspective in the future. But I'm pretty sure it's not going to be sector-specific regulation, but it's still going to be competition law, but more precise and more with a regulatory character.
Vandy.
So I think I'm really curious about how the impact of some of the privacy law changes, what the impact will be on competition. So, on this portability issue. So if you essentially make it easier for consumers to vote with their feet and take their data with them, then what are the implications of that? So I think we'll be seeing that, and that's going to be interesting. And I think, secondly, obviously these big tech firms are under investigation. Big tech firms are in lots of different markets doing lots of different things, and I think it's going to be interesting to find out once we get deeper into their practices, all this value that's been built by these firms, whether there really is a competitive issue or not. I think sometimes these things from a distance, big is bad, and lots of different kinds of data all together under one roof seems scary. But then when you get down to how they're actually being used and the value that's being created for consumers, you might find something different. And so I'm actually really curious how this kind of plays out. And glad that there's the ability to look at it more with more factual care.
Peter, you let us off, so
Okay.
how about you close us out?
Thanks. Well, I'm going to do a short-term prediction about big data. I think there's going to be a huge amount of discussion now and very soon about location data with COVID-19, because contact tracing is so important to addressing the epidemic. And on the other hand, if you think about location data, you tend to be at your house, which is very identifiable, or maybe at your place of work. It's very hard to de-identify location data. And so there's going to be huge databases and reason to do it for health reasons. And then how to have social controls on that around technical controls to mask the data, or administrative controls about who gets to get it or who doesn't get to do it. So we're going to have a social debate on big data when it comes to the healthcare crisis we face. And I think that will help teach us other lessons about big data as well. Thanks.
Again, thank you all for taking the time to address what I think are important issues. Okay, back to you, John.
All right, thanks, Ankur. Sergey, let's start with you. What are some of your takeaways from today's panel?
Well, I really enjoyed learning more about data portability. It sounds like an exciting potential solution for at least some of the concerns posed by big data. But the devil is, of course, in the details. And I think that concept demonstrates some of the potential tension or potential interplay between competition concerns on the one hand and privacy and security concerns on the other. It sounded like data portability may be a positive on the competition front, but potentially could raise issues related to privacy and data security. Just shows how nuanced and interesting this area is.
Anna, what about you? What are some of your thoughts?
So it was interesting to listen to the panel because they talked about the essential facilities doctrine, and this was something that I have put on the back of my mind for a long time. But for better or worse, this seems to be part of the policy conversations among antitrust enforcers. We've heard that Germany is considering revising their competition law to make it more clear that the essential facility doctrine should apply to in the online world. And I suspect others are thinking about it and are following suit, and that we will have to look at how the EU and how the US will apply the essential facilities doctrine to the online world.
Sergey, back to you. Other takeaways from you?
Yeah, so I agree with Anna, that essential facility discussion was interesting. And of course, the reason people are bringing up essential facilities and whether companies have to share data is because there's that issue of whether data is a barrier to entry. And on that front, I thought the Tinder example was very informative because here you have a market, online dating, where you clearly have strong network effects. Data seems like it would be quite important. So on the surface, you might think that data may be a barrier to entry and incumbents would have a very large advantage. And yet, as we heard in the program, you had a new entrant succeed and catch up to and even overtake the incumbents very quickly in this market. So of course, one should be cautious not to generalize too much from any one market. Each market has its own specific facts and requires a separate analysis. But the example does make you wonder and make you think about whether data is really that insurmountable a barrier.
Anna, any last thoughts from you?
No, I think Sergey summarized it pretty well.
Great. Okay. In that case, I'd like to bring in Amadou Ribeiro. Amadou is a partner at Matos Filho. It's a Brazilian firm, but Amadou works out of the New York office. Amadou is also a member of the International Development and Comments Task Force at the ABA Antitrust Law Section, a very, very busy group that monitors developments around the world and, where appropriate, puts in comments, stating the section's position on various issues, which frankly have become very, very important to the development of international competition law. Amadou, welcome.
Thank you, John.
Tell us a little bit about the initiative you've been working on.
John, this is a report that we put together with the support and collaboration of multiple committees within the section of antitrust law. And in this report, we identify and summarize the positions expressed by the section on some of the more common antitrust and privacy issues relating to tech markets, digital markets in general. Big data happens to be one of the most important topics there. The goal of the report is to assist the work of the section in providing comments to other agencies as they seek input on proposals for change in their own competition laws. The reason why we thought of this report is that in the course of our regular work, the International Developments and Comments Task Force observed that a lot of questions arising with respect to U.S. antitrust law are also commonly found by foreign antitrust agencies when it comes to digital markets. We've submitted comments regarding new approaches to antitrust law in digital sectors in Australia, the European Union, the UK, and other jurisdictions. And so the issues were arising with such a frequency that would suggest to us that they will continue to be of great interest for an extended period of time. And so our task force, with the approval of section leadership and the support of various committees, we took this effort in the hopes that, first of all, we would have consistency in our comments, as we've always had and would like to continue having. So with the report, we looked at prior comments from 2017 to 2019 to see what position was taken by the section on those common issues. And then we also wanted to have everything in one place to help put together comments in future comment opportunities to help expedite and simplify the process of developing such comments. This is especially important in the work that we do with comments because we always have very limited time, and also because, frankly speaking, the issues that we're talking about, some of them do provoke heated debate, and it's important to have a firm position with respect to them that's ready to go, so to speak. We just briefly, we talked about in the report about issues in different areas, and I'll just briefly mention them here. Market definition and market power, big data, as I mentioned before, a lot of issues with respect to mergers, exclusionary conduct, algorithms and artificial intelligence, privacy and data security. In each section, we describe the issue, we identify prior section documents expressing views on that very issue, and then we summarize how we believe that the section should position itself with respect to them. I'd like to just finally, as a final note, just mention briefly the reports, the committees that were involved in this work. In addition to the IDCTF or task force, we had the Economics Committee, the M&A Committee, the Media and Technology Committee, the Corporate Counseling Committee, the Unilateral Conduct Committee, the Cartel and Criminal Practice Committee, and finally, the Privacy and Information Security Committee. Thank you, John.
Amadou, it sounds like a big project, a lot of cats to herd. Give me a sense, how long is this report?
It's close to 200 pages. I think part of it, maybe half of it, is summarizing the issues and then having a recommended approach on each of them. And then there's a big appendix where we summarize all prior comments on those issues that the section has submitted to various agencies around the globe.
And the report is available on the section website?
It should be, as we are recording it, it is in the process of being put on the section website, and so it should be available pretty soon.
Great. Okay. So look for that report. It's really important stuff and represents a lot of work by a lot of people on a very important issue. All right. With that, I want Amadou, I want to thank you. Anna and Sergey, also thank you for coming in and giving us your insights on today's program. I'd like to thank Ankur and the folks that participated in today's panel. Really important stuff. There's a lot of hard work that goes into this. Lastly, I want to thank folks listening in. We really appreciate you. Until we speak again, please be safe and be well.
Thank you for listening to this 2020 Virtual Spring Meeting edition of Our Curious Amalgam. It is produced and shared around the globe by the American Bar Association Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard and would like to become a member of the ABA Antitrust Law Section, visit us at ambar.org/antitrust to learn more. If you have feedback for the podcast or are interested in participating in a future episode, please reach out at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.